and welcome to the LLG Grapevine podcast. You're listening to Helen McGrath, Head of Public Affairs, and Dennis Hall, LLG Bulletin Editor.
Hi, everyone.
Well, Dennis, what a relatively quiet week this has been, although Michael Gove has made some interesting comments, but more on that later. I see you've got an item on judicial review. What's the latest?
Yes, there's been a timely reminder in a recent case about what you cannot do in a JR. Here's the story. The Law Society Gazette contained an interesting article this week about judicial review. In a recent case, a judge has stressed that the High Court will interfere with a public authority's decision only if there's been an error of law. In a judgment this week refusing a teacher's application for review, Mrs. Justice Farby said that the High Court will generally not engage in a general inquiry about the facts of the case in JR proceedings. She emphasised that in judicial review proceedings, it is not the function of judges to enter into an inquiry about the relative advantages and disadvantages of any aspect of education policy in the UK generally, or in any particular county. The court's jurisdiction is supervisory, which means in very broad terms that it will interfere with the decision of a public authority only if there is an error of law. Now, the judgment states that the teacher in this case sought to highlight safeguarding concerns about a pupil whom the teacher does not teach. However, Mrs. Justice Farby said people who apply for JR must have legal standing. The claimant said that she should be allowed to bring the claim because she is acting in the public interest and as a whistleblower who has brought information about child X to the attention of her employer, which she believes should be brought to the attention of the court. Mrs. Justice Farby went on to explain, however, if the mere assertion that she represents the public interest was sufficient to give her standing, it would mean that the courts would have no way of distinguishing between a person with a genuinely sufficient interest and others. That is not the law, she said. Farby added that courts will be slow to intervene in issues of social policy that raise multifactorial considerations for decision makers. In my judgment, she said, the claimant is using the banner of the law in an attempt to persuade the court to enter into a policy debate that is ill-suited for judicial review. But she stressed that her ruling was a permission decision and is not citable in other cases. Nonetheless, these judicial comments are timely in light of recent trends in the use of judicial review in recent years and the criticisms that have been levelled at JR by the government.
Well, adopting an inclusive, low-emission and climate policy compatible with growth requires the UK government to pursue growth-enhancing fiscal and structural reforms that support low-emission and resilient investment, backed up by cost-effective and efficient climate policies. With this in mind, the government proposed the introduction of new investment zones, where environmental and planning laws would be relaxed to encourage infrastructure and business growth. This, it argued, would accelerate both housing and infrastructure, which the UK needs to drive economic growth, by cutting back on, quote, unnecessary bureaucratic requirements and processes which slow down development. In response to the investment zone announcement at the time, numerous organisations raised concerns as to whether investment zones could be delivered without adverse impact on climate change and green policies, and whether a balance could indeed be kept between the two. However, that was then, and this is now. Investment zones were a Trush initiative, of course, announced in that much talked about mini budget, and we now have a new Levelling Up Secretary in the form of Michael Gove. Last week, in an interview with Times Radio, Gove said, I will be looking with the Chancellor, with the Environment Secretary and with the Prime Minister at the proposals that were drawn up when Liz was Prime Minister, and anything that might in any way undermine environmental protections is out. He also suggested that capital spending, including HS2, could have to be cut in order to bring down inflation. So this is a bit of a moving feast. Whether investment zones are watered down or ultimately suffer death by cuts is the real question of the moment. Now, Dennis, I know that many councils are very concerned about cutting budgets even further at this time. What can you tell us?
Well, yes, indeed. The financial situation for councils is beyond seriousness, and more cuts are expected. But what about those services that councils are under a legal duty to provide? Here's my take on this. Libraries and children's centres are closing, and home pickups for young disabled people are being cancelled as councils try to meet a £3.2 billion budget shortfall next year. With inflation and energy prices eating into budgets, local authorities across the UK are facing a record black hole that is unlikely to be filled by central government, as the Treasury is seeking to squeeze spending to make up for a £30 to £50 billion shortfall in the public finances. The trade union, Unison, collected data from 391 councils compiled through Freedom of Information requests and financial statements, and found that almost 9 in 10 have predicted a budget gap in the 2023-2024 financial year. Unison said that its data shows the biggest budget shortfall of £80 million next year is being faced by Birmingham City Council, which cites the Liz Truss mini-budget as one of the contributing factors in its worsening finances. Unison's investigation found that waste collections, leisure centres, nurseries and other vital services are already being cut in some local authorities in England, Scotland and Wales as they prepare for a tough year ahead. Asked about the £80 million shortfall at Birmingham, which is the biggest local authority, council leader Ian Ward said, "Like councils across the country, we're currently working up budget proposals for 2023-24, and everything possible will be done to safeguard the vital services that people across Birmingham rely upon." But monitoring officers, here's the question for you. What advice do you give where proposals for cuts involve a service which the council is under a legal duty to provide? Is it satisfactory as a legal defence to say that your council can no longer afford to meet its legal duties? Answers please on the LLG forum, which you'll find on our website.
Well, no doubt that's one conversation of many to be had at the LLG Governance Conference later this week. Now, reported in the Local Government Lawyer, the Public Administration and Constitutional Affairs Committee have published a report entitled Governing England, which concluded that the government should urgently create a cross-party commission on the future governance of England to tackle the view that the current arrangements for governance are preventing the effective delivery of policy and services. The report describes the current governance system, which includes local government of metro mayors, as a patchwork and opaque system, leaving citizens wondering about which democratic representative or institution is accountable for decisions that affect their lives and livelihoods. Further, that the system has created geographical inequality. Chair William Ragg MP said, "We urgently need an overhaul of governance arrangements to empower local decision-making and restore public faith in accountable local governance. It is important that such long-term fundamental reforms are not controlled by any one party. That is why we are calling on the government and the opposition to set up a cross-party commission to develop proposals for sustainable and durable governance arrangements for England." So historically, we know that Gove favours reform, but whether, with what is probably only around 18 months for effective policy change prior to the next election, such a monumentous change is capable of being moved forward, remains to be seen. Dennis, I see you have an item on what qualities lawyers need to handle the many pressures that arise in their careers. Tell us more.
Yes, indeed, Helen. This is an interesting article that I found that members should take a closer look at. See what you think. Priscilla Adu is a trainee solicitor and student representative at the Junior Lawyers Division of the Law Society. In a Law Society Gazette article last week, she offered some wise words on the importance of resilience during the course of a legal career. And, if I may say, being a solicitor has many, many challenges and stresses for which you will need to prepare. These challenges may change in nature as your career progresses, but being resilient is an important attribute, as she says, and you will need to demonstrate it on many occasions. As Priscilla says, you should strive to be a resilient lawyer because it is a critical skill that can be used when facing adversity. Being resilient will help you persevere through difficult situations. She likes to call it the art of not giving up. And Priscilla offers 5 tips that can assist you in becoming a resilient lawyer, no matter what stage you might be at in your own career. Number 1, do not let rejection define you. Now, this is easier said than done, of course, but it is not uncommon for a student or professional seeking to enter the legal profession to have setbacks. Something that helped her to persevere and maintain a positive outlook was to keep in mind the end goal of qualification. Do not allow your past rejections to stop your future progression. Number 2, learn from mistakes. Senior managers must appreciate that making mistakes is inevitable, especially for those in the earlier stages of their legal career. You may worry or be anxious about your work. That is natural, and we all do it. It is how you respond to these things that defines you. But remember, you must never face these issues alone. Mistakes will happen, so share them, discuss them. Good employers want to fix the problem, not the blame. Number 3, remember the importance of your own well-being. As lawyers, our clients turn to us in times of distress to seek a resolution to the issue that they're facing. It's important to remind yourself that although you're in a position to serve your clients' needs, your own needs too must also be looked after. You're not expected to be unaffected by stressful situations that arise at work, but you must push yourself to find a coping mechanism. And can I add a personal contribution here? As a young local government lawyer, I started by doing lots of prosecution work, and frankly, I hated it. Then I was simply terrified of speaking in public. But I can honestly say that when I took up amateur dramatics in my local village hall, which I loved, it cured me not only of my stage fright, but also my anxieties about appearing in court. Giving the impression of confidence is everything in litigation. Indeed, when I look back and think about it, it is a sort of acting. Number 4, be adaptable. Miss Adu is on the money when she explains, throughout your legal career, you will encounter time-pressured situations, complex work, and often demanding hours. Being adaptable is a great skill to have because it allows you to manage the considerable pressures and changes that can arise from working in the law. And finally, number 5, don't strive for perfection. When things do not go as perfectly as hoped, this can often leave us feeling deflated and defeated. But you should not expect to be perfect in everything you do. Constantly striving for perfection can lead to more anxiety. Again, you need to work out what will enable you to cope with this. It's all about confidence. And in legal practice, you have to move on, keep looking forward, not back, and get on with your next assignment. Sound advice all round, in my view, and there's more in this article. And remember, you're not alone when dealing with the challenges and anxieties of being a local government lawyer. We've all been there and felt the same.
Well, I certainly have, I can tell you that. Now, councils have called on the government to delay new adult social care reforms, warning that the reforms are underfunded. Councillor James Jamieson, chairman of the LGA, said at the National Adult and Children's Conference, it's important we get the reform and the funding for social care right. And we're calling yet again for government to sit with councils, people with lived experience, our partners, working age adults, old people and unpaid carers in order to develop a system that works for us all. Also at the conference, the LGA said that urgent government action is needed to tackle the unacceptable crisis of lone asylum-seeking children being held in hotels, warning that during July and September this year, 1,322 lone children were housed in hotels by the Home Office for an average stay of 16 days. Councillor Louise Gittins, chair of the LGA's Children and Young People Board, said, "It is deeply concerning and unacceptable that these hotels, which were introduced as a short-term emergency measure, remain in use, especially as the number of children going missing from them continues to grow." In July, the Home Affairs Select Committee reported that the disappearance of separated migrant children from hotels was extremely concerning. It said the government must immediately and clearly confirm where responsibility lies for every aspect of safeguarding children housed in accommodation. And on that note, that's it for another edition of the podcast. You can read more on that, the items discussed today, and many more besides by going to Bulletin number 40, available on the LLG website now. So it's goodbye from me.
And from me too.
Thank you for listening. Have a good week, everybody.